Bland Boozley testified under oath last week, and now the expert extortionist is fighting tooth and nail to prevent her deposition transcript from being made public. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. As I shared with you all yesterday, last week, in addition to her deposition, lawyers for both sides met with Judge Lyman in his courtroom in New York City to discuss the subpoena that Subpoena Serena issued against Justin Baldoni's lawyer, Brian Friedman, and his law firm. The judge did not issue a ruling at that hearing, and afterwards, both sides sent letters to the judge with more information. Team Baldoni Wayfarer sent a letter to the judge with an exhibit and a request that the exhibit be put under seal for a week. That was a transcript of the word Saladista's deposition that happened on Thursday. And Baldoni Wayfarer told the judge, "We respectfully request that the court not rule on this letter motion to seal for 1 week so that the parties can meet and confer, and Miss Lively may file a motion for continued sealing if she so chooses." And that is what led us to today and a fiery response from Team Ridicula. They don't want her deposition transcript getting out there. Betty Poop's legal team was accusing Baldoni's attorney, Brian Friedman, of defaming her. Defamation is a very serious allegation for one lawyer to make of another lawyer. And in their letter to the judge, the Baldoni Wayfarer legal team says that upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves, and then that part was redacted. And then they cite Exhibit A, which was the transcript of her deposition, and the exact point in the transcript where she talks about the only ongoing smear campaign about which she has personal knowledge. I speculated that it might be me, and it would be wrong. Well, in a letter filed moments ago, this is one of the most explosive documents that I've seen since covering the It Ends With Us saga. Ezra Hudson, one of the lead lawyers for Colleen Hoover's bestie, tells Judge Lyman, quote, "Pursuant to Federal Rule of Civil Procedure 12F and the court's inherent power, Miss Lively respectfully moves to strike the Wayfarer defendant's letter attaching the entire uncertified rough draft transcript of Miss Lively's confidential July 31st, 2025 deposition testimony, and to deny the letter motion to seal as moot. In rushing to file on the public docket the entirety of the 290 pause, it was filed under seal and nobody saw it. Nobody saw it. Nobody saw it. But our girl Ezra is making it seem like we did. She tells the judge, in rushing to file on the public docket the entirety of the 292-page transcript, which nobody has seen, on the day they received it with no plausible legal reason to do so, the Wayfarer defendants and their counsel have proved Miss Lively's point. The transcript was ostensibly filed in support of their argument that there is no basis to assert that Brian Friedman or his firm have participated in, fueled, and advanced a smear campaign against Miss Lively such that their conduct has amounted to public relations work rather than that of an attorney. But, in fact, this tactic of attaching the entire transcript perfectly demonstrates the counsel as PR agent role, because there is no conceivable legal purpose to file the whole transcript, particularly given that it has not been reviewed, corrected, or finalized, and a mere 2 pages of it were cited in their argument. And looky here, there is a footnote of note. Ezra says, even as to the 2 pages cited from her deposition, the transcript, it makes no sense to suggest that facts in Miss Lively's personal knowledge italicized, as opposed to facts developed from the public record, from the investigations of others, and through discovery, would be particularly relevant to, never mind dispositive of, the nature of Mr. Friedman's conduct in connection with this action. Moreover, the Wayfarer defendants compromised the confidentiality of the proceedings by applying only a single narrow redaction in their letter, while openly characterizing it in unredacted argument, substantially disclosing their spin on the alleged substance of Miss Lively's testimony. The letter and attachment should be seen for what they are: a manufactured excuse to force the transcript into the public domain as fodder for the Wayfarer defendants' media campaign. Pause. Babe, we know, yeah, that's most likely what it was, an attempt. But that attempt is not gonna happen. Judge Lyman is in your pocket and on your side. You know how the law works. They know how the law works. They did nothing illegal or unethical, no matter how much Team Pinocchio tries to spin it. This is just lawyers lawyering. And the lawyers are the real winners here, making millions and millions of dollars from both sides. Ezra's letter continues. It is surely not lost on the Wayfarer defendants that, given the pending motion to seal, the burden is on Miss Lively to file a letter motion explaining the particular reasons for seeking to keep any of the 292 pages of the transcript under seal. Yeah, that's not lost on them. They literally told the judge that. Duh. They said that in their letter, which you're responding to. The Wayfarer defendants and their counsel hope to make Miss Lively defend the continued sealing of the transcript so they can advance a false narrative that Miss Lively is afraid of her deposition testimony becoming public, which she is, which is entirely untrue and deeply harmful, they claim. Miss Lively affirmatively pursued this litigation with the full intention and desire to have her testimony heard in a legal process governed by the rules of evidence, which publicly filing this rough draft transcript in this manner substantially undermines. To suggest otherwise is part of an ongoing character attack that Mr. Friedman has been advancing to undermine Miss Lively's credibility and taint the jury pool. Oh, no, you're not. They're already trying to set up an appeal. They're already planting the seed that she's not going to be able to get a fair trial. BS. But part of me also loves the fact that they're afraid. They know they don't have the receipts. They know they don't have the proof to win their claims. But they argue that filing that exhibit under seal for a week is an abuse. They say that is not a proper use of confidential discovery material or this court's docket. Accordingly, Miss Lively respectfully requests that the court strike the uncertified rough draft transcript from the record and order the Wayfarer defendants to file only that portion of the transcript cited in their August 1st letter, which portion should be filed under seal. And there's a footnote there. It says, from the inception of this litigation, Mr. Friedman has falsely accused Miss Lively of being afraid to testify and delaying her deposition, and has made a spectacle of it in a number of ways, including ghoulishly suggesting that the deposition take place at Madison Square Garden, as this court is well aware. The conduct leading up to the deposition resulted in the court granting a protective order governing the location and attendance at the deposition. And, they add, to be clear, Miss Lively's deposition transcript should remain confidential and under seal unless and until it becomes the subject of a legitimate filing, and then only if any presumption in favor of public access is overcome. By itself, the transcript is deposition discovery material, which, like other materials merely exchanged among parties in discovery, plays no role in the performance of Article 3 functions. And the law is clear that parties may not force material into public view by manufacturing reasons to file it on the public docket, as is well established. Quote, the mere filing of a paper or document with the court is insufficient to render that paper a judicial document subject to the right of public access. There was a little typo there. Underscoring the futility of the Wayfarer defendant's strategy, the Second Circuit has made clear that material submitted solely for the court to determine whether it must remain confidential enjoys no presumption of public access. Here, where the Wayfarer defendants and their counsel have manufactured the sealing dispute itself, not only is there no presumption of public access to the materials they have filed, these materials have no legitimate place on a judicial docket. Finally, even if they had been submitted in connection with a legitimate filing, the 2 pages cited in the Wayfarer defendant's letter, never mind the entire transcript, would not warrant unsealing, as materials submitted in connection with and relevant to discovery motions, as opposed to substantive filings more determinative of the merits, are subject to a lesser presumption of public access. Consistent with their goal of creating a media circus, and this is where we get some extra juicy tea. Consistent with their goal of creating a media circus around Miss Lively's deposition, it also appears that the Wayfarer defendants immediately leaked details from the deposition to the tabloid media. This began by selectively sharing from a source in the room that Mr. Baldoni was in attendance, apparently to advance a storyline that the deposition was a face-to-face showdown between Mr. Baldoni and Miss Lively. They then include a footnote with several links to articles reporting this. They continue. The next day, more leaks from a source close to the deposition described in detail Miss Lively's attire for the deposition, also revealing those who accompanied her, mocked Miss Lively's legal team, and then discussed extensively the Wayfarer defendants' themes from their now dismissed case. The narrative created was that Miss Lively needed a large contingent of people with her to testify, while misleadingly suggesting that only Mr. Baldoni and Mr. Friedman were present for the deposition on their side. The reality is that Miss Lively testified across the table from Mr. Baldoni, Jamie Heath, Steve Sorowitz, Melissa Nathan, and Jennifer Abel, all of whom attended this deposition in person, as well as 8 attorneys representing the Wayfarer and Wallace parties, 2 of whom questioned her. Now, I've been in depositions before. Having 8 attorneys present, that's extra and unnecessary, because only one attorney would be objecting to anything at any one time. Wild. And they're mad. Filing the uncertified rough draft of the deposition transcript when it serves no legitimate litigation purpose is disrespectful to the types of allegations at issue here and to the litigation process. It harms harassment and retaliation victims like Miss Lively, who already bear physical and mental health consequences from the underlying incidents and are forced to repeatedly relive the trauma through litigation, including court filings, depositions, and court testimony. And in this case, also through seeded press and social media gossip and scrutiny about her confidential testimony, thanks to the Wayfarer defendants. Such tactics also have an untold, chilling effect that serves to silence other sexual harassment victims. Accordingly, Miss Lively respectfully requests that the court, her bestie, grant her motion to strike the uncertified rough draft deposition transcript from the docket, deny the letter motion to seal as moot, and order the Wayfarer defendants to file only that portion cited in their August 1st letter under seal. Respectfully submitted, Ezra A. Hudson. First, we know how the judge is going to rule. But secondly, more importantly, what is she trying to hide? Or what is she afraid of? Or ashamed of? Huh? If I stood on business, I would not be afraid of the truth. You clock that? But the gaslighting goddess is afraid of the truth. She likes only the truth that she can manipulate, I think. What do you think? This was quite the fiery response. I love it. Let's discuss everything in the comments section.